Hey everybody, how's it going? Welcome back to Copper Jacket TV. So as somebody who lived 97, 98% of my life in the state of California, I am used to seeing an attorney general play games and use deceptive tactics to try and stall, delay, or even prevent the outcome of a very important Second Amendment case, especially when it comes to so-called quote-unquote assault weapons. But I'm not used to seeing that game be played at the Supreme Court. And we have one attorney general right now who is doing exactly that. And we need to talk about it because this has got to be one of the most important Second Amendment cases before the Supreme Court right now. So let's talk about it. Okay, so let's go ahead and talk about what's going on here. So we're talking about the case of Snope v. Brown. This is one that you guys might know. It was Bianchi v. Frosch, Bianchi v. Brown. Bianchi is no longer involved, and so it's Snope v. Brown, Brown being the Attorney General of the state of Maryland. Now, this was a petition for cert back in August to the Supreme Court. So the Supreme Court has had this since August. The Supreme Court was on recess until the first Monday of October, and now they've started conferencing cases again. So they've started telling us what cases they're going to take, what cases they're going to deny, and so forth, right? So we're kind of back in the whole Supreme Court process again after they took their recess. Now, we'll get to what just happened today here in just a second, but since the petition for cert was filed to the Supreme Court on August 23rd, that meant that Attorney General Brown had until September 23rd to file his response. Now, he needed a little bit more time, so he filed for a 30-day extension, which to me I find kind of ludicrous given the fact that this is a law that has stood in Maryland for the past 11 years. You should know everything there is to know about it. It's gone through the district court level. You've had to fight it there. It's gone through the appellate court level. You've had to fight it there. You should have all the discovery, all the information, all the details on text, history, and tradition that you could possibly need at this point to fight this up at the Supreme Court. Plus, you should have known that this was coming. But still, you say you don't have enough time, so you file for that 30-day extension. The Supreme Court grants it. That means now that A.G. Brown has until October 23rd to file his response. But guess what? That's not enough time. It turns out that there are so many Second Amendment cases happening in Maryland right now that he has his crew spread too thin, and he just doesn't have the manpower in order to take the case to SCOTUS. So he files this today. Okay, so this was just filed today, October 9th, 2024, and it is in regards to Snope v. Brown, where it says, "Dear Mr. Harris, the petition for writ of certiorari in this case was placed on the court's docket on August 23rd, 2024. The response was initially due September 23rd, 2024, but at respondent's request under Rule 30.4, the time for filing the response was extended 30 days until October 23rd, 2024. That's the date where we are waiting to see if the Supreme Court would then put it in conference and let us know when they were going to take it, right? So after they filed their reply. Respondents request an additional extension of 30 days so that the response would now be due before November 22nd, 2024. The extension is necessary because of the press of other assigned work. Notably, undersigned counsel and others associated with this case are involved in significant litigation matters, including those related to the collapse of the Francis Scott Key Bridge. See the matter in the petition, etc. The matters also include other ongoing Second Amendment litigation, including a response to a petition for writ of certiorari in this court in Maryland shall issue et al. V. Moore. So that is another case. Comprehensive litigation challenging Maryland's sensitive places laws in the Fourth Circuit, and a challenge to Maryland's red flag law currently pending in the Supreme Court of Maryland in Willie v. Brown. The requested extension is necessary to ensure that the undersigned counsel and others can devote sufficient attention to those proceedings as well as the responses to the two petitions in this court. Now, you might be thinking to yourself, okay, that sounds kind of reasonable. They have a lot going on. They like to violate the Constitution quite a bit, and so they get sued a lot. They don't have the resources to be able to take care of that. But this is where the games come in, okay? This is where the tactics come in for them, and the politics come in for them as well. in these other cases that they're talking about, the case of the Fourth Circuit, maybe a case at the district court level, those cases, you can request extensions in those as well. So obviously they have to file a response in those other cases. And they're saying that because of that litigation, they don't have time to devote all their attention to the one that's at the Supreme Court. But they can simply ask the other courts, the lower courts, for an extension in those cases so that they can prepare for the big case that is up at the Supreme Court. I can almost guarantee you that the Supreme Court is not going to be happy about this. The justices themselves are not going to be happy about this. But again, that's where the games come in, right? So we have multiple cases. We have cases about carry. We have cases about red flags. We have things going on that actually do need the attention of the Attorney General and his staff, like the bridge. We have a lot of stuff going on here. Why is the attention being focused on that case, right? The very important case, and they're not asking for the extension from the lower courts? It's because they want to delay, and they are trying to delay the case at SCOTUS. It's all part of the game to make sure that they can drag this out up there as long as possible. Now, this was just filed today, so I'm not 100% positive that the Supreme Court is going to grant that 30-day extension, but they probably will. Now, you got to ask yourself, okay, so that gives you about, 6 weeks now if they grant the extension for you to be able to respond. But given the caseload that you mentioned in that document, do you really think they're going to be able to respond even within those 6 weeks? Probably not. This is all a tactic to get busy with those other cases so that they can, again, use that to try and extend this and maybe try and extend it even into next year and just delay this for as long as possible. That typically works on a state level. If you look at the state of California, they'll delay things, for as long as possible. And you take a look at Miller. Miller was delayed. It was sent up, sent back down. It's been bounced all over the place, right? They use delay tactics there as well. And then finally, the Ninth Circuit says, well, we're just going to put that case on hold completely for now until we have a result in this other case, and then we'll take that case up again. And so it's just kind of sitting in limbo. And that's what they're trying to do here again with this Maryland ban. That is, if you ask me, one of the most consequential cases sitting before the Supreme Court right now, because I know, without a crystal ball, I still kind of feel like we're going to have a win in this. I don't want to say I know we're going to win this one, but I'm fairly certain we're going to win this one. That's just how I feel in my heart. But I feel like we're going to get a win here, and Maryland's going to be the one that is going to be responsible for overturning all of the bans across the country, and this is going to be on them, and that's going to be on Brown, the Attorney General of Maryland, that he was the one. That's a big if, the Supreme Court actually decides to take one of these, because as you know, they haven't taken one yet. So we're going to wait to see what happens here, but hopefully they take it, because if they do, I'm just going to throw out a prediction that we get a massive win out of this, and that's the end of it. For California, New York, Washington, New Jersey, Illinois, Hawaii, any other state that has a ban like that, it's going to be wiped out by this. They know that. They're trying to delay it. I just wanted to let you guys know what's going on. Thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.